Contract law, no doubt, is actually one of the legal courses that give most of the students headache, especially at the beginning part of it. And the reason for this is because a lot of contracts has certain terminology and various principles that are not quite relatable to young students who recently joined legal field. But don't worry, if you can relate to this or you find yourself confused whenever you open contract law textbook, I encourage you to stick to this video because I will break everything you need to know about contracts. And not only that, I will give you a step-by-step approach on how you can face this contract law to make your A. Then at the end of this video, I will give you some tips on how we are going to deal with the issue of forgetting cases at the examination hall. So I encourage you to stick to this video because you are going to learn a lot. We are starting with the basic understanding of law of contract. That is to say, we are going to see what the contract law are all about. And don't forget, today is just an introductory class on law of contract. So I'm going to give you a step-to-step approach on to understand this very course. Then we shall also go forward to consider the overview of contracts. Then subsequently, we proceed to all various topics in law of contracts. So it's actually basically the introduction class to the law of contracts, because before we dive into the intricacies that surround contracts, we ought to better appreciate the meaning and the overview of what contract law is all about. But before we proceed, my piece of advice for you is that as we embark on this lecture video, as far as law and study is concerned, you must go extra mile to read ahead of your lecturers. If you are to credit all your papers, and become a successful lawyer, there is no way you can achieve this other than a good research. And also don't forget, Lord Dennis said that God forbid that a lawyer should know all the law, but rather he should know where to find the law. And there is no better way to find the law than to do a research before your lecturers. If your lecturer has started already, there is no better way to credit that paper and to make A in your contract than to read extra mile, because contract law has a lot of cases. You can't talk about a sentence without pointing a case. When you open it, the difficult I encountered during my time in second year was that whenever I opened contract law, everything I was seeing was cases. You can't talk about any particular principle without having about 5 cases on that particular principles. Look, at least 5 cases. So this is a very taxing for students who just finish their legal methods on legal system, depending on the institution you find yourself. So it's a very taxing something. So that's why you have to do your research. You have to be up and doing. Stand ahead of your lecturer. Don't wait for your lecturers. The better way to learn, the better way to appreciate, even when your lecturer will be teaching it that very subject or topic, is to read ahead of him. And in this very channel, this is where you are going to not only to read, but you are going to be told, and you will see the paths to follow and how to navigate it. So that is a secret I have to break. I want to tell you now that you should consider this video as a tutorial video and get your pen and get your jotter, because everything you are going to learn, you can merge it with that of your lecturer's note. That is a way a student who wish for an excellent making of results will always the path the person should follow. So I encourage you to get yourself ready, get your jotter, and follow up whatever we are going to do, because it's going to be beneficial to you, so that when your lecturer will commence lecture, or if your lecturer has commenced lecture, you will better understand and appreciate whatever your lecturer may have told you or will tell you as we proceed on this journey. If you found any term difficult, put it on that comment section. Once I'm free, I'm going to answer your question. Believe me when I say I'm going to answer you, as I'm here to your service to help you, because I felt so bad during my own time because of the challenge. So I'm willing to help other people as well, not to encounter the same difficulty I encountered. The question now is, what is contract? There are several authorities that has defined contract, but we are going to proceed with ordinary layman understanding of contracts. Let us even understand the perspective of what contract is all about before we can go ahead to itemize the authority that you can use to define your contract. So let us even consider what a contract is all about, how a contract is formed, how does an individual even create a legal binding agreement in the first place. So now the basic understanding, the contract law reduced to its simplest definition as well as meaning, could just be defined, contract could just be defined as an agreement between two parties creating mutual obligations that are enforceable by law. So simply put, contract can be defined as a legally binding oral or written agreement which exchanges any or combination of goods, services, money, and property. So what did we just say? We say that contract is an agreement between two parties. Contract is an agreement between individuals who has exchanged promises among themselves in order to be bound under a particular agreement. So I want you to properly understand the meaning of contract. As a law student, a social science student has approached you. A social science, let us assume that a social science student is making a project or writing a project, and that thing has to do with the topic law. It has to do with anything pertaining to law. He's doing a research work, a project or 10 paper work on legal matters. Then he has approached you as a 200 level student or as a 300 level student to help him out because he believes that you have the, at least like Rodney said, God forbid that a lawyer should know the law, but he rather know where to find it. He believes, he counts on you that though you may not know the whole law at your disposal, but you have a way to find the law. Then he approached you, he tailored all he presented his own arguments, he presented all his own prayers and everything, asking you to help him. Then you say, well, thank you for meeting me, thank you for having hope in me, thank you for counting on me. You are in the right place, I'm going to help you. But of course, you know that this thing calls for research. I'm going to use my data, I'm going to use my time, my precious time as a law student, you understand? Until when exam reach, you understand what I mean by precious time of law student. So you then say that I'm going to face this challenge using my data, using every bit of me. So you know you're going to be taxing. So I want you to give me something in return so that I will be encouraged. And I also, that thing will offset all the cures I will incur, both psychological stress, both emotional stress, as well as that of my own precious time. And as well as physical costs like data I will be using to make the research and printing those papers and do everything and give you. So you are going to give me some certain money. Okay, the social science said, well, yes, your plan is good. How much are we looking at? Okay, I think you have to give me 15K so that I will help you to do this work. And I promise you, I must do it neatly. You are speaking as a law student. I will do it neatly and also make everything, the 10 paperwork neat, itemize my authorities. In fact, I will give you everything you need, 100%. No cap. So you people then agreed that this will be binding on you people. So there has been what is known as contracts. This contract in this term is oral contract. You people may not have written it down, but the social science accepted that is going to find something for you. Then you accepted that you are going to deliver your work, not only deliver your work, but neatly. What has transpired between you two is known in law as contracts. Like, do you just understand? I want you to understand, because when we begin to blow all this English, it appears as if to say what we are saying is far-fetched from us. Every day we enter contract. So what you people has formed now is known in law as contract. There is agreements. There is a mutual agreement, very important. But you should know that not all agreements are binding. As we proceed now, when we shall get to a brief overview of element of contract, I shall be telling you what is needed for a contract to be binding. I don't want to get into there now because I want to carry everybody along. Let's start with the general meaning. Then after, we'll go to the elements that are associated with this very contract we just talked about. So now there has been a contract between them. That contract in this sense is oral. You didn't pick your pen to write anything down. The social science student didn't pick his pen or her pen to write anything down. You people have agreed, have a mutual mind that this contract is binding. If any party breaks this contract today, tomorrow, and this kind of contract is still executory on your both part, we shall also consider types of contract in our next video, but not in this one. So just relax. Whatever I'm saying, by God's grace, we are going to understand it. So the contract that just transferred between you people could be seen as oral contract and also an executory contract. Executory contract meaning that you have exchanged promise. You have not executed your own of writing it. The social science student has not executed his or her own of paying you the money. You people are still under planning agreements. What just happened between people are agreements. And then what do we say that contract is? We say that contract is an agreement between two parties or between parties, creating a mutual obligation, very important, that are enforceable by law. Creating a mutual obligation that are enforceable by law. So we have seen now when we say that contract can be described as a legally binding oral That is what just happened now. Or written agreement which exchanges any or combination of goods, services, money, and property. So there has been an exchange of something here. Why you exchange your own precious time to write a project for social science student, the social science student has also exchanged her precious coin. That thing, that Ruby has to exchange his or her own precious money, resources to give you in return of that. That is why we say that contract has been formed. That is all. That is meaning of contract. But of course, as a law student, you understand what I mean? You cannot just come and say that contract can be defined as a mutual agreement binding two parties, which if any party breaks it, this person did, you will fail, you will get zero. Like you just be joking. So that is not what you're going to write for your lecturer. You are going to say according to the lecturer will listen to you. Contract has been defined in line with this. Your lecturer will listen to you. In law, we are considered as nobody. We, the student, are considered as nobody until we become an authority, until we become Professor Kingsley. When I begin to talk, you know that I'm a leading authority, Professor Sagay. That is what the lecturer wants to hear. So that's why we are going to consider now the definitions from the respectful author and respectful jurist who know their onions. Like they know their salt, they know their sugar, they know everything in that very field of law. Not only onions, they know their sugar cane. So do you understand? So we now going to go to consider the leading authority, those that will give our work vibes. Because when you begin to argue in law, you don't argue mainly on your opinion. So in law, you don't just say contract can be defined. Yes, I know that contract is a mutual agreement. Yes, who said it? From who? Whom did you learn it from? So that I will learn from you. That the lecturer wants to know where you got the idea that contract is a mutual. Of course, the lecturer already know it's a mutual agreement. The lecturer wants to hear from where is it coming from, where is this assertion. That's why as a law student, it's advised to begin your question with quantitatively, according to, in line with this, in line with that, here, indicator. Your lecturer will be like, you are waking your lecturer will pay attention while reading. Remember, our pursuit here, anybody partaking in King's Advocate Network, our pursuit, our major aim here is to credit, not only credit, to make A. So that's why I'm giving you tips by tips. Remember, this lecture is a step-by-step guide. We shall proceed gently and we cover everything you have to know about law of contracts. Then, when your lecturer begins, you will flow. And if your lecturer has started, you will not only flow, but you even go ahead of him. Believe me, we are going to do that. We are going to achieve it. So we proceed. For us to consider the authorities in this field now, we shall start with the greatest of all time in the world of contract, Professor Trietel. Of course, you can't talk about law of contract both within and outside without talking about Professor Trietel. He's the leading teacher in that field, which other author, in fact, he taught many authors in the field we have it today. So he's a leading author in contract, and we must mention him as far as definition of contract is concerned. So he is a Father Abraham in this case. He's our father. So we have to mention him. So according to Professor Trietel, in his work, The Law of Contract, he defined contract as an agreement giving rise to obligation, which are enforced and recognized by law. The factor which distinguishes contractual obligation from other legal obligation is that they are based on the agreement of the contracting parties. Do you understand? So Professor Chitty not only defined contract for us, let us take that again. He said that contract is an agreement giving rise to obligation which are enforced and recognized by law. Then he went ahead to give us tips. He went ahead to give us some small fish. He said, the factor which distinguishes a contractual obligation from other legal obligation is that they are based on the agreement of the contracting parties. You can't talk about contracting party here, just the tips of what they call, you will do it in second semester. If you are still in your first semester, it's probably in second semester, to the best of my knowledge, you will see privity of contract. Privity of contract means that if you are not a party to a contract, you cannot enforce that contract. So that's why it's just a tip of it, is what Professor Trietel has brought. Because in that definition, he said that the factor which distinguishes a contractual obligation from other legal obligation is that they are based on the agreement of the contractual party. So just like the example we gave earlier, that agreement between you and social science students is between you two. A person from agric science cannot just come and jump into that contract and try to enforce it. If you break the contract as a law student, the only party in the world, both within and outside, and in this world and the world next to come, that can sue you or take you to court is that social science student. Nobody can ever do it because it is an agreement between two of you. It is a binding mutual understanding between social science student, social science student and law student. Do you get the point? So that's what we are saying. It is the Trietel made us to understand that the only thing that distinguishes it from other legal obligation is that it is only binding to the parties. In other legal obligations like law, of course, the general law binds all in the society, whether you want it or you don't want it, it is binding. But this very law of contract, this very contract law we call, will only bind parties that are associated with it. I hope you are getting this point. Please, if you don't understand, ask me question on the comment section. I don't want to left anybody behind, because after explaining this thing as a beginner guide, when we delve deep, I will not be explaining it like this. So I want everybody to flow like this. So now we have seen the definition of Trietel. So when you are defining Trietel now, you understand the meaning of everything. And I want you to know this Trietel definition, I think, is about 3 sentences. It's just as long as Trietel. You have to cram it. Yes, I said it, cram it. It will not kill you, just cram it. Cramming it, you can just, then when you want to define it, you can see, according to Professor Trietel, you quote everything Professor Trietel say, then you use that quotation and elaborate more, just like I'm saying. Everything I'm analyzing now is Professor Trietel definition. The reason why I'm saying is you cram it is because it will go a long way to help you. If you didn't cram it, the least you can do is just to use the word, you have done. What will you say again? But if you quote that exact quotation, you can then go ahead to analyze it. You'll be analyzing it. Then it will also give the lecturer the lecturer will then understand you know what to do. However, I didn't say you should approach everything with cramming. I just say cram this very definition. As a law of contract student, you have to know what someone like Professor Trietel say. You have to know what someone like Professor Sagay say in contract. You have to know what they say. This is just 3-line, 4-line sentences. Knowing it will also help you. So understanding is very important. Once you can't, and I don't even advise you to cram something you don't understand. Like we just explained it now. I believe you can understand it. Then take the action of cramming it so that you will remember it and analyze it on your paper and give your work flow. Because you are not just going there to write 4 sentences and submit your paper. You are going there to fill your paper within the short period of time you have. It will do you need if you quote the exact quotation and then analyze all of them to save you time. Then you will use that precious time to be doing other things in the hall. So I encourage you to pick up because contract demands a lot. And we proceed to that of Sagay. So according to Professor Sagay, of course, you know that Professor Sagay is a prominent legal scholar in Nigeria who is well respected for his contribution to Nigerian law of contract. So talking about Nigerian law of contract, we must call Professor Sagay of blessed memory. According to Professor Sagay, contract can be defined as an agreement which the law will enforce or recognize as affecting the legal rights and duties of the party. A contract can also be defined as a promise or set of promise the law will enforce. So, do you see now how Sagay defined his own contract? So, according to Sagay here, contract is an agreement which the law will enforce as affecting the legal rights and duties of the party involved. So, this in general is not just far from Professor Trietel's definition. So, he just said that it's an agreement which the law will enforce. I hope we are following. Then now, let us consider Chitty on contract. You will hear about this. If you have not started hearing it, you are going to hear it as we proceed on the law of contract. So Chitty on contract define contract as a promise or set of promises which the law will enforce. It is legally binding agreement made between two or more parties. Chitty define contract as promise or set of promises which the law will enforce. It is a legally binding agreement made between two or more parties. All of them is still saying one thing: agreement. So let us proceed with this definition. Then we are going to identify the unique thing about all these authors' definitions. We are going to itemize all the things. Unique thing, I mean things that are obtainable in all of them and things that stands as an element of contract worldwide, especially in all common law jurisdictions of the world. So we proceed to Sir Williams' Anson definition on principle of law of contract. According to Sir Williams, contract is a legally binding agreement between two or more parties by which rights are acquired by one or more to act on forbearance or on the part of the others. So, I said I don't know, I think it will be much needful if we consider this whole definition, then we point out the unique things about them. But as we proceed, this man, Sir Williams, as then was, had brought another perspective on what we should know now. He brought another thing, which is forbearance. This thing, forbearance, now is what we would even refer to as consideration, but we are going to see those elements. I'm just going to give you another fifth definition of law of contract. I believe the thing is displayed on your screen, so I believe you should write this thing down. It will do you a favor. Like I said, get your jotter when we started. I believe you have gotten your jotter. Make sure you pick this definition down, so that when I will be explaining this unique thing about them, you begin to see it in your own book, as well as it, because it will help you. So this definition, imagine you if I told something like that is related to definition of law of contract, because of course I don't think there's any law lecturer that will expressly tell you to define contract. It's not obtainable. That's why you are a learned, you'll be addressed as a learned colleague subsequently. You have to be learned. So lecturers will not basically come and say define contract, itemize it. No. They will twist the question, they will put it in a hypothetical problematic way. You are the person to know the importance of contract and why it's needful that you define it before proceeding to answer whatever you are answering. You are the person to use your sense, your number 1, your number 6, your number 5. If you are using number 0, it's still relevant. So you are the person to use any number you are making use of in your head to know that I'm required to define contract here. I'm required to put Professor Trietel contract here. I'm required to put Chitty on contract here. I'm required to define Sagay here. I'm required to bamboozle my lecturer with definitions of contract on this problem question. You are the person to know that. No person will tell you where to put that. So don't expect something like define contract unless your lecturer wants to do Father Christmas to you. That is if you are writing your own during the Christmas era. Lastly, we go to tertiary and fifth note. So according to them, in the law of contracts, contract is a promise or set of promise which the law will enforce. The law of contracts is the body of legal rules governing such promises. Do we get this point? Now, I want to ask you a question. Like, what did you basically notice about all these definitions of contracts? What is the unique thing about them? I want to challenge you. Just like, I believe you wrote this thing down or you are seeing it in that very screen. Among all these definitions, what do you think is unique about these whole definitions? Just think, try to think somehow. What do you think? Think. What do you think is unique about them? So now, let us consider most of those things. Put it in that comment section. I want to hear from you. Tell me what you think about something that are unique, that are generally unique, that are featured in almost all these definitions. There are one or two things that are featured almost in all these things we just said now. These things, this notable uniqueness that binds all these things are: number 1 is agreement. What is an agreement? Then it becomes the question. I started by explaining to you with social science and law student contract they formed. They started by agreeing that this person is going to do this thing, this person is going to do that. However, agreement is not a contract. Agreement is not binding. Why all contracts comprises agreement? Not all agreement comprises contract. Did we get it? I said, why all contracts has an agreement as its element? Not all agreement has a contract as its element. I just pray that somebody understood what I said. I said, why all contract is an agreement? Not all agreements are contracts. Why all contract is an agreement? Not all agreements are contract. What do I mean by that? I mean that there could be a valid agreement between you two, but it's not yet totally automatically grown to contract. Before it could be grown to contract, before the court could enforce it, there must be offer. There must be acceptance. There must be consideration. There must be intention to enter into obligation. That is what they call in law consensus ad idem. Yes, consensus ad idem. Intention to enter into a contract. There should be consensus ad idem, mutual agreement, mutual understanding between you two. So we are going to consider this thing, and this thing is what they call element of contract. Do you understand? I said before agreement could metamorphose into what is known in law as contract, it must precede, it must have the element of some other element, some other things that can make a contract to stand before the court. Remember, the essence of what we are saying is because if problem arises between you and the social science students, and you people approach the court, before the court could enforce that contract between you two, there were certain other elements which needs to be there. If that other element is not there, that contract is null and void, because there is no other element putting it making it a valid contract. What are those elements? We are going to consider it. However, I want you to know that element of contract is a wide, big topic. Offer is not just as I made you offer to buy something. Offer goes beyond just in law of contract. Acceptance is not just yes. Offer acceptance goes beyond that in law of contract. Consideration is not just money. Consideration goes beyond that. So each element has its own dedicated video. So I encourage you to go to my playlist section from today after watching this video. If any element that has not been posted there within subsequent week must be posted there. All the element of contract must be discussed on this King's Advocate Network. That's why I encourage you to subscribe, so that whenever a video, because every week, every interval of week, a video will be posted, so that YouTube will notify you, then you can watch it immediately and follow up. So I encourage you to subscribe, and when you subscribe, turn that bell, turn it on to all notifications, so that you'll be notified. Without it, you'll not be notified, and it will do you more harm if you just watch this lecture without following it up to merge your understanding about it. If you just go with half-baked knowledge, it will not be helpful to you. So I encourage you to subscribe and always stick here so that you could see it. So we are going to briefly itemize it as this concept, because if you delve into each of them as we suppose, for the sake of our exam or other thing we might be doing with it, we will not end this video. This video will even take 10 hours, and I'm not even plan this video to exceed at least more than 40 minutes. I don't even want it to reach 1 hour, but if it managed to reach 1 hour, it will be fine, because I believe what we will learn from it. So, but I want to make this video as short as possible. So now we have identified agreement as being a unique something in all of them. So what we are now trying to say is that we are trying to know that is, in as much as all of them say that contract is an agreement, there are other things that follows immediately. Some say that contract is an agreement. Some say that something like there could have been exchange. Some say that there could have forbearance. All these things are known as consideration, acceptance, offer. So agreement is just a part of a contract, but agreement is not the whole part of a contract. Why all contracts must have an agreement? Not all agreements must be contracts. Do you understand? And it was in line with this agreement meaning, that is to say that agreements is necessary to contract, but not all agreement is contract, that Toby JSC as then was in the case of NEJ and Zekem Construction Nigeria Limited. I'm going to the citation is there on your face, it's in there on your screen, so you can check that case, because that case is really necessary and relevant to the meaning of contract, especially as concerning agreement. So in that case, Toby JSC stated that why it is necessary that agreement, in fact, why all contract is rooted on agreement. It is also relevant to understand that not all agreements are contracts. So I'm just trying to tell you that there could be an agreement between two parties, but there may not have been contract. Let me use this example of social science student and that of art law students. The agreement here is that they are going to perform a particular work. They have made an offer between themselves. They have made an acceptance between themselves. But what about consideration? Consideration now has not been formed between these two parties. So if any party, like, why am I even going far? You are a law student. You as a law student, or I as a law student, if I bridge the gap between me and this social science, now, if the social science student has not paid me, and then he has not furnished any consideration, the consideration, that's why I'm saying, I don't even know whether in fact, let's proceed this way, because I think we also understand it more when we treat consideration. So the consideration there is that for consideration to appear, for this contract to be binding, there must be element of consideration. We have, offer has been in existence, yes. He proposed to me to write, then I accepted, yes, offer has been achieved. Consideration, intention has been achieved. Consideration in this part is still executed. So what we have now is executory consideration. He has not given me the money, and I has not performed the work. So if I call him on the phone and say, Mr. Man, this work you just gave me, guy, I know if you do, like, I just opened my Google, like, I don't even understand all the whole thing. Who is the lecturer that give you this kind of assignment, safe? I used to, I know go do again. This thing happened in the morning, and they called him in the night to lament, to tender a book of lamentation the second. Then, after listening to your book of lamentation, he said, okay, well, it's fine. I'll leave it. The contract dies off. But if after listening to your books of lamentation, and he said, what do you mean? I told you to do this thing this morning. You said that you are going to accept it. Do you know what we are doing? Are you not a law student? In fact, I'm taking this matter to the court. Are you crazy? Boom, he end the call. Tomorrow, they will serve you with notice. Service, personal service. You will know personal service if you are not done introduction to civil proceeding. Then they will tender personal service payment to you. You are summoned by Enugu State High Court, this. But in this case now, you have a valid, there has not been contract. But wait, before you just conclude there has not been contract, wait, don't rush. There could be contracts depending. Though if the social science student has given you money, like if he has given you money and you collected that money and again called him to disappoint him, he's going to sue you for breach of contract because he has furnished consideration. He has made an offer. You accepted the offer unequivocally. You accepted it unapologetically. You accepted this straightly and expressly that you are going to do it. Now you disappoint him, he's going to sue you. If he has given you the money, it doesn't matter if he has given you the whole money. Whether he gave you part payment, you are liable. And what will the court do? The court will either enforce you to write that assignment. They will mandate you specific formats to write that assignment. Or my very noble social science could say that he suffered damages of 1 million and you are going to pay him 1 million because he wanted to submit that 10 paper tomorrow or that evening. That's why they say lawyers are liars. Not that any other thing will lie, but just because a party can just claim anything. Like now, the lawyer to the social science student, if I'm the lawyer, I can claim that this my client. Remember that social science could have said that maybe he told you that he's going to submit this assignment or this 10 paperwork or do this project at the end of semester. Then he claimed that it was that evening that he wanted to submit it and that this contract happened 10 years ago or even when you got your admission. They could lie. The judge will accept. Of course, the judge is not there. The judge is ruling under the balance of probability of evidence before him. So you don't blame my man. My man has no hand. So that evil is between the lawyer and their God. If they have their gods or God. So it depends. Like he suffered a lot of harm. Therefore, the court will award 1 million. That is it, my dear. Because there has been a valid contract. What made it valid is there has been an offer, there has been an intention to enter into contract, there has been acceptance, there has been what is known as consensus addendum. Meeting of the mind. You people agreed in your own mind that you are going to carry this thing out. Then there is a consideration, very important. Consideration is one of the elements the court will look for. Don't worry if you don't know what consideration means. When we get also to the main topic, the main video on consideration, because consideration is a big topic. Everything you are doing, everything the lecturer will test you as a first semester law of contract student, you must cite consideration. And you cannot go to court without knowing consideration. So I encourage you to either check my playlist or wait patiently for that very video. So I encourage you to do any of this. If the video is there, you check it. If it's not there, believe me, consideration is coming, depending on the time you are watching this video. So that is it. If on the other hand, that contract just ended that way, the social science, you told the social science, my man, just relax. When I'm done with this, I'm going to present this paper. Then you pay me. Okay, said okay. Then if you pick up your phone and call the social science in the evening and told him that you are not going to continue with this. If the social science man let him go and take you to the Supreme Court without even starting with the State High Court, nothing will happen. Yes, I'm with you. Nothing. Invite me, I will defend you. Nothing is going to happen. If you let him go to the private counsel in London, nothing is going to happen because there has not been a valid contract. Even if he has not pushed any consideration. However, it all depends. Mind you, I said he told me that he's going to submit this paper in 2 weeks' time. Let us agree. He said he's going to submit in 2 weeks. Then I called him this evening. Why would this contract took place in the morning that I cannot continue? If you let him go to court. I will meet him there and we argue it out. We wear suit and argue it out. Who is he? So that is just to tell you because the contract, I still did justice to it by informing him on time. But on the other hand, if that 2 weeks time has expired, and I pick up my phone and call him that I'm not going to continue, he can institute an action for specific performance for award of damages. If also this thing in the night or in a 2 days, 3 days, it just depends on reasonable time. I can't actually say it's particular time. It depends on the court under the balance of evidence to check the hardship, whether there is still probability of social science student to get another person who could have done it. If there is no chances of that, I will be held liable for it because I have accepted it. And the consideration in this case is the detriment that he has passed through, the counting on me. Though he has not given me money, but he has counted on me. Now let us turn the story upward, downward or upward, angleward, whichever one, second word. So what about on the other hand now, if I have finished the project? Remember, we agreed that I will do the project here, then submit and you're going to give me money. Then I have successfully finished the product and in my own honorable lawyer as I be, a man of integrity, as everything, as the future upcoming, I surrender this paper to this man with everything I have done neatly and just excellent. And this, my social science student begin to tell me cock and bull story. Well, I don't think I will collect it. In fact, I don't need it. I'm not doing project. Who are you? You are going to give me my money. We die here. I'll just take him immediately to the court. So the court will enforce it. The court will enforce it because I have suffered detriment. Detriment is now in consideration. Forbearance is now in consideration. Painful stress, everything I did is now the consideration on my own part. Then it's now left for him to fulfill his own contract. He cannot argue, well, we just agree, and you have, did we say, it's not when you, like, he had no argument before the court because I have fulfilled my own part of the contract and he must fulfill it, whether he like it or not. Either the court order him to pay me money or the court could, in fact, there is no other thing the court would even do other than, because on his part, there is nothing like specific performance. Specific performance is it to terminate everything I have written or to put it under fire. Which specific performance is he performing specifically? So there's no specific performance, so it's only on my part that they could mandate me to write it, or if it depends on how the judge wishes to go about it. Either he slams damages on me, then I will pay money and I will split him for the inconveniences and the brouhaha and the whatever kind of lackadaisical, everything that could be injustice I have meted on him. That is what agreement is all about. Then we proceed immediately to the third unique thing about all the definition, which is promise. What is promise? For contract to exist, there must be promise. There must be promise is unique to all contract. In this social science scenario now, did you see the promise? The promise is that I'm going to write the project. The promise on his own part is that you're going to pay money. So in every contract lies a promise. So the other party should know that actually there was a promise. That's why they say consensus added them. There should be meeting of mind. Did you see now why we say that promise is unique to contract? We are saying we are trying to analyze the whole, that when you open your mouth to be saying that contract is an agreement, is a promise between two parties, you will know what you are saying. Do you understand? So if you are following this video and you really find value to what I'm saying, like if you really understand, if you understood me loud and clear, make me hear that by subscribing to this channel. Just subscribe and I will hear it. Don't worry, I'll hear it. And also give it a like, give it a heart, and I'll hear it. I believe you understand. However, if you don't understand, put your question there. Believe me when I promise that whenever I come online, whenever I'm free, I will answer you. Whether in the night, doesn't care. But once I answer you, the YouTube will notify you that I've answered you, and you are going to come and see my reply. Yes, we help each other to grow. That is our plan. Then we proceed immediately, no time. The third element here is the party. Then the party Nikitobi JSC again has defined a contract as an agreement between two or more parties, which creates a reciprocal obligation to do or not to do a particular thing. All of them is before you in the screen, so you can go and check out that case. So in that case of Oriental Bank, Nigeria PLC and Bilate, the learned justice of the Court of Appeals then was define contract as an agreement between two or more parties, which creates a reciprocal legal obligation to do or not to do a particular thing. So now this summarizes our definition of contracts, which means that it could be either to do or not to do a particular thing. Yes, a contract could exist. A contract could exist on the ground not to do a particular thing. Yes, you might form a contract. For instance, you might take my land. Or what would I even say? In fact, let me just use a simple example. You might slap me. Then I will say, why did you slap me? Are you okay? I then plan to sue you under the law of tort, because it's a tortious liability. You slap me, that has to do with tort. It's not a criminal offense. To the best of my knowledge, it's not a criminal dependent. So you are giving me a slap. I can just sue you under the law of tortious liability for claim and everything. Then you say, well, please, my dear, please, dear Kingsley, I like you. Please don't go to court. It was just the devil entered the side man that give you a dirty slap. Please forgive me. But I'm going to give you, for the sake of this slap, I'm honoring you with 1 million. I'll say, okay, my friend, you are good to go. Who am I, Kwan? In fact, the matter has ended. It was not even planning to institute an action. It's just I was joking. But since you are giving me 1 million, it's okay. We round it up. Then we call it a day. And later, you see, there has been a contract between us. The contract between us is that you promised to give me money, and as well as persuade me for the dirty brown slap you gave me. You gave it to me, which I could have ordinarily go to court to look for my damages on other tortious claim. But battery and assault and everything. So I could have gone to court to slam you for doing this thing to me, for embarrassing me with slap and everything before the general public. So now I would then take it to the court. But now you have persuaded me. If you fail to give me that money, I will suit an action against you now under the law of contract because you have breached a contract. What was the contract? The contract was that you gave me a slap and you promised to give me money and I left. That is what I say now. Go back to that Nikitobe definition. I'm just using it to explain Nikitobe definition. He said, is defined as an agreement between two or more parties which creates a reciprocal legal obligation to do. The emphasis is on this thing I'm saying, to do or not to do a particular thing. So I wanted to go to court. Then the contract between us prevented me to go to court to do that action, to institute that action. So did you see why I just use this simplest hypothetical analogy to drive home my point of that contract could be either that you are refraining from doing a particular thing or something you could have done ordinarily, but based on the contract form you refrain from doing. If I go to court, the court will either mandate my learned person that gave me that dirty brown slap to give me that 1 million he promised. They could even, if not only that, they could even calculate all the cost of the cases, all the cost of going to court and calling a particular lawyer, Esquire, to represent me on a particular court, or calling a particular barrister or solicitor to represent me on the court. So the court will look into that and award me my damage. So that is just what contract is all about. And again, don't forget, contract must be between parties. Very important. Contract must be between parties. So now we are considering this unique element. I want now for us to understand the source of contract law. Is another thing you have to know. Let's briefly consider the sources of contract law. Where is contract law coming from? Where is it emanating from? In as much as we now see the meaning, I believe everybody at this point has had an overview knowledge. This video is always here for you. In case you didn't, anytime, maybe within your exam or after your exam, you can always come, just type introduction to law of contract by King's Advocates. It's going to show on your YouTube channel. And you're going to watch it. So it's always here for you online. So you can check it either a date your exam anytime. You can consider it while reading or making notes anytime. The video is always there. Tidaking.com. So basically, when we talk about sources of contract law, we should know that contractual relations are basically between individuals, and therefore contract law is a form of civil law. So contract law is civil. I believe at this point you should know what it means by civil law. If you have dealt if you have done justice to your legal method and legal system, you should know what we mean when we talk about civil law and criminal law. So contract law is under the realm of civil law. That is to say, you cannot maintain an action against me that can convict me or lead me into prison, no matter whatever will happen. The only thing the court could do is to order for specific performance. Like that person that slapped me, I cannot sue him under the law of contract ab initio, originally. It's only when he has promised me, then when he has made a promise that's going to give me 1 million, then I forgone my plan of suing him under the law of tort. Then if he breaches that agreement, I'm suing under the law of contract. I can even sue jointly, claiming for the slap he gave me, the brown slap he gave me under the law of tort, and also claiming for the breach of for even breaching his promise, making me to go emotional psychological trauma by having been happy, having been energized by 1 million amount of money. Now he has say that he's not going to give me that money. Like he will energize me. He energized me earlier, but he has made me to feel by suffer emotional harm, and because of that, the court should be award me damages on law of contract and law of tort. So I'm telling you now that civil law is basically what law of contract is all about. You cannot maintain an action under somebody, against somebody under the criminal law because he refused to do a particular thing. Like that social science gentleman, if you refuse to fulfill that contract, you cannot sue him for crime. He didn't commit any crime. Neither me as a learned gentleman, if I refuse to carry out that work he gave me as a law student, nothing will happen to me because it's not a crime I committed. I can only be ordered to perform it or to pay damages. That's all. So I'm trying to tell you that sources of contract is basically rooted under the civil law. The dominant source of contract law now is the common law, number one, case law, and also some current enactments. So the dominant source of law of contract is common law. Common law basically guides all the jurisdictions that are governed by Britain, that are once governed by the Britain. So the Britain introduced common law to all jurisdictions, including countries like Ghana, Nigeria, and South Africa, Zambia, and Kenya. And in fact, there are numerous that were under the British colony. So all countries that are under British colony basically operate under the common law. Australia. So that is to tell all the laws, basically what guides contract is common law. As a law student who is watching this video on introduction to law of contract, you are going to see this explain why you are seeing cases here and there. Do you understand? So whenever you open law of contract, don't be like, why is this people stressing my life? Why is this people after my life with cases? It is so because the only law, the only source of contract law are the cases. Case law are the sources. Now, what about the tips I promised you at the beginning of this video that I'm going to give you as regard to not forgetting cases during examination hall? Yes, that is just one of the tips out of many things I have for you. So I encourage you to click this video above to watch that very video. We cannot compile all of them in this very video so that the video will not be long like that of the name of Melchizedek. This video needs to be shortened so that the YouTube system will work well with it. So if you wish to see the tips on what you have to know and approach it, because what you have just succeeded doing is that we have introduced ourselves, we have adapted ourselves to everything that has to do with contract. As regards to introduction, we have seen the various definitions of contract and now to some extent the element. But what about things, the holistic knowledge you need to know? How are you going to approach these cases? How are you going to understand, make sure that when you are reading, you do understand what you are reading? How are you going to make sure that you don't forget anything at the examination hall? Because to read is human, but to remember is divine. Yes, for me, to read is human, but to remember is divine. So it's that divinity that I want to show you in this very video. Click the link on your screen above now. That video is going to lead you to where you are going to find the various tips that will help you in order to navigate through this contract, because contract is actually a course that have come to stay. They will not change it. Go and see the tips there as we continue in so many other lecture videos. Don't forget to like this video. Don't forget to share this video to your relevant group so that they will also learn. And most importantly, have you subscribed? Subscribe, please, beloved. Subscribe as you go and watch this very video on tips you have to know so as to pass your law of contracts. Thank you and remain blessed.